Good everyone, this is our pre-recorded discussion in Group 7 presented by Valdivesa Nikiwi, Turtle Christine, Gonzales Bichiram, Tubagag Jermaine Boykins A, Villavic, Emmanuel Pagsuyuin, Villacampa Eljon GRC, Torres Disime, Tuwanda Janino G, Cavalfin Charlie GRB, Louis J. Tanador. Article 48, penalty for complex crime when a single act constitute two or more grave or less grave felonies, or when an offense is necessary means for committing the other. The penalty for the most serious crime shall be imposed, the same to be applied in its maximum period. Philosophy behind plural crime. The treatment of plural crime as one is to be lenient to the offender, who instead of being made to suffer distinct penalties for every resulting crime is made to suffer one penalty only, although it is the penalty for the most serious one and it is the maximum period. Purpose is to pursuance of the role of the pro reo. If the complexing crime, the penalty will turn out to be higher and do not complex anymore. Example: murder and thief, killed with treachery, then stole the right. Penalty if complex, reclusion temporal, maximum to death. If treated individually, reclusion temporal to reclusion perpetua. When you say reclusion temporal, 12 years and 1 day to 20 years imprisonment. When you say reclusion perpetua, life imprisonment, a term of 20 to 40 years. A complex crime is not just a matter of penalty, but of a substance under the revised penal code. Plurality of crime may be in the form of compound crime, complex crime, composite crime. Now under the Article 48, there are the three kinds of complex crime. One is compound crime, the second is complex crime, and composite crime. When you say compound crime, is one where a single act produces two or more crimes. When you say complex crime, strictly speaking, is one where the offender has to commit an offense as a means for the commission of another offense. It is said that the offense is committed as necessary means to commit the other offense. Necessary should not be understood as indispensable. It shall be considered absorbed and not giving a rise to a complex crime. Composite crime and special complex crime. This is one which a substance is made of more than one crime, but which in the eyes of the law is only a single indivisible offense. This is also known as a special complex crime. Examples are robbery with homicide, robbery with rape, and rape with homicide. Compound crime. The compound crime and the complex crime are treated in Article 48 of the Revised Penal Code, but in such article, a compound crime is also designated as a complex crime, but a complex crime are limited only to a situation where the resulting felonies are grave or less grave felonies. When you say grave felonies, those which attaches capital punishment or afflictive penalties. Examples: death penalty. When you say less grave felonies, penalties from arresto mayor to prison correctional, including destero and suspension. Whereas in compound crime, there is no limit as to the gravity of the resulting crimes, as long as a single act bring about two or more crimes. Strictly speaking, a compound crimes are not limited to grave or less grave felonies, but rather it covers all a single acts that result in two or more crimes. A person threw a hand grenade and the people started scampering. When the hand grenade exploded, no one was seriously wounded. All were merely wounded, it was held that this is a compound crime, although the resulting felonies are only slightly. Now, here, both compound crime and complex crime and composite crime, at least two crimes must be committed, whether it is a compound crime or a complex crime or composite crime. Even if at least two crimes are committed, in the eyes of the law, it treated only as a one crime because it proceeds from a single criminal resolution or intent.
Article 70, Successive Service of Sentence. Article 70 of the Revised Penal Code states that if multiple penalties could not be served simultaneously, the imposed penalties may be executed successively and following the order of their severity. And also, under Article 70 of the Revised Penal Code, a convict should serve two or more sentences simultaneously if the nature of the penalties will so permit, and if not, then the sentences are to be served successively. However, it limited the maximum duration of a convict sentence. Under the threefold rule of Article 70, a convict can be punished only up to 3 times the most severe penalty imposed, and such maximum period shall not exceed in 40 years. The maximum duration of the convict's sentence shall not be more than threefold the length of time corresponding to the most severe of the penalties imposed upon him. So we do have here the threefold rule, and the first is maximum duration of the convict's sentence, not more than 3 times the most severe penalty imposed, and the second is maximum duration shall not exceed in 40 years, and the third is subsidiary imprisonment. This shall be excluded in computing for the maximum duration. So the threefold rule shall apply only when the convict is to serve 4 or more sentences successively.
So Article 76, it talks about the legal period of duration of divisible penalties. The legal period of duration of divisible penalties shall be considered as divided into 3 parts, forming 3 periods: the minimum, the medium, and the maximum. So the table showing the duration of divisible penalties and the time included in each of their periods. So the first penalty is the reclusion temporal. Time included in the penalty in its entirety is from 12 years and 1 day to 20 years, and time included in its minimum period is from 12 years and 1 day to 14 years and 8 months. Then time included in its medium period is from 14 years, 8 months, and 1 day to 17 years and 4 months. Time included in its maximum is from 17 years, 4 months, and 1 day to 20 years. The next penalty is the prison major absolute disqualification and special temporary disqualification. So, time included in the penalty in its entirety is from 6 years and 1 day to 12 years. Time included in its minimum period is from 6 years and 1 day to 8 years. Time included in its medium period is from 8 years and 1 day to 10 years. Time included in its maximum period is from 10 years and 1 day to 12 years. The next penalty is the prison correctional suspension and destierro. Time included in the penalty in its entirety is from 6 months and 1 day to 6 years. Time included in its minimum period is from 6 months and 1 day to 12 years and 4 months. Time included in its medium period is from 2 years, 4 months, and 1 day to 4 years and 2 months. Time included in its maximum is from 4 years, 2 months, and 1 day to 6 years. The fourth one is the arresto mayor. So arresto mayor, time included in the penalty in its entirety is from 1 month and 1 day to months. Time included in its minimum period is from 1 to 2 months. Time included in its medium period is from 2 months and 1 day to 4 months. Time included in its maximum is from 4 months and 1 day to 6 months. And the last penalty is the arresto menor. The arresto menor is time included in the penalty in its entirety is from 1 to 30 days. Time included in its minimum period is from 1 to 10 days. Time included in its medium period is from 11 to 20 days. And last is time included in its maximum is from 21 to 30 days.
Chapter 5 Execution and Service of Penalties. Section 1 General Provision. Article 78. When and how a penalty is to be executed, no penalty shall be executed except by virtue of a final judgment. A penalty shall not be executed in any other form than that prescribed by the law, nor with any other circumstances or incidents and those expressly authorized thereby. In regulations of a provision of the law, the special regulation prescribed for the government of the institution which is the penalties are to be suffered shall be observed with regard to the chapter of the work to be performed, the time of its performance, and other incidents connected therewith. The regulations of the convicts among themselves are, and other person, the relief which they may receive, and their diet. The regulation shall make provision for the separation of the sexes in different institutions, or at least into different departments, and also for correction and reform of the convicts. That's all. Thank you.
Article 79 Suspension of the execution and service of penalties in case of insanity. When the convict shall become insane or the imbecile after final sentence has been pronounced, the execution of said sentence shall be suspended only with regard to the personal penalty. The prevention of the second paragraph of circumstance number 1 of Article 12 being observed in the corresponding cases. In the corresponding cases, if any time the convict shall be recover his reason, his sentence shall be executed unless the penalty shall have prescribed in accordance with the prevention of this code. The respective prevention of this section shall also be observed if the insanity of imbecility occurs while the convict is serving his sentence.
Article 80. The suspension of sentence of minor delinquents. This article is amended by PD 603, which is the Child and Youth Welfare Code. The decree was signed by President Ferdinand Marcos on December 10, 1974 and took effect on June 10, 1975. RA 9344. If a child commits a felony when he is 15 or below, he is exempted from criminal liability. If he is over 15 but below 18, but he did not act with discernment, he is exempted from criminal liability. If he is over 15 but below 18 and he acted with discernment, he is not exempted from criminal liability and he will be prosecuted just like any other criminal. So, if the offender is 16, therefore, he is over 15 but below 18, he committed a crime and acted with discernment. During the trial, it was established and proven that he is guilty from beyond reasonable doubt. RA 9344 or Juvenile Justice and Welfare Act of 2006. This refers to a child in conflict with the law. A child in conflict with the law is a child who alleged as, accused of, or adjudged as having committed an offense under Philippine laws. Under Section 38 of RA 9344, once the child who is under 18 years of age at the time of the commission of the crime was found guilty of the offense charged, the court shall determine and ascertain any civil liability which may have resulted from the offense committed. However, instead of pronouncing the judgment on conviction, the court shall place the child in conflict with the law under suspended sentence without need of application. Provided, however, that the suspension of sentence shall still be applied even if the juvenile is already 18 of age or more at the time of the pronouncement of his guilt. Therefore, as long as he is 18 years and below at the time of the commission of the crime, even if he is above 18 at the promulgation of the judgment, he can still benefit from the suspended sentence. Under Section 40 of RA 9344, if a child is under suspended sentence, the court shall decide to discharge or to extend the sentence for a specific period of time or until the child attains the maximum age of 21.
Article 81. When and how the death penalty is to be executed. The death sentence shall be executed with preference to any other penalty and shall consist in putting the persons under the sentence to death by lethal injection. Section 1. Article 81 of the Revised Penal Code as amended by Section 24 of Republic Act number 7659 is hereby further amended to read as follows. The Director of the Bureau of Correction shall take steps to ensure that the lethal injection to be administered is sufficient to cause the instantaneous death of the convict. Pursuant to this, all personnel involved in the administration of lethal injection shall be trained prior to the performance of such task. The authorized physician of the Bureau of Correction, after thorough examination, shall officially make a pronouncement of the convict's death and shall certify thereto in the records of Bureau of Correction. The death sentence shall be carried out not earlier than 1 year nor later than 18 months of the judgment has become final and executory, without prejudice to the exercise by the President of his executive clemency power at all times. Section 2. Persons already sentenced by judgment which has become a final and executory who are waiting to undergo the death penalty by electrocution or gas poisoning shall be under the coverage of the provision of this Act upon its effectivity. Their sentences shall be automatically modified for this purpose. So the Section 2 tackles that anyone who's convicted into a certain crime that must undergo the death penalty is affirmed unless certain circumstances happen that would alter the decision. Section 3. Implementing rules. The Secretary of Justice is coordination with the Secretary of Health and Bureau of Correction shall within 30 days from the effectivity of this Act promulgate in rules to implement its provision. Section 4. Repealing Clause. All laws, presidential decrees and issuance, executive orders, rules and regulation or parts thereof inconsistent with the provision of this Act are hereby repealed or modified accordingly. Section 5. Effectivity. This act shall take effect 15 days after its publication in the official gazette or in at least 2 national newspapers of general circulation, whichever comes earlier. Publication shall not be later than 10 days after the approval thereof. So the section 3 to 5 tackles about the death penalty was known to the public.
Article 8. Notification and execution of the sentence and assistance to the culprit. Culprit is a person who is responsible for a crime or other misdeed. The court shall designate a working day for the execution, but not the hour thereof. And such designation shall not be communicated to the offender before sunrise of said day. And the execution shall not take place until after the expiration of at least 8 hours following the notification, but before sunset. During the interval between the notification and the execution, the culprit shall, insofar as possible, be furnished such as assistance as he may request in order to be attended in his last moments by priests or ministers of the religion he professes and to consult lawyers, as well as in order to make a will and confer with members of his family or persons in charge of the management of his business, of the administration of his property, or of the care of his descendants.
Article 83. Suspension of the execution of the death sentence. The death sentence shall not be inflicted upon a woman within the 3 years next following the date of the sentence, or while she is pregnant, nor upon any person over 70 years of age. In this last case, the death sentence shall be commuted to the penalty of reclusion perpetua with the accessory penalty provided in Article 40. The imposition of capital punishment or the death penalty was abolished under Republic Act No. 9346 on June 2006. Notwithstanding the suspension, the framers were mindful that the law was merely temporary, as the Constitution provides that excessive times shall not be imposed nor cruel, degrading or inhuman punishment inflicted. Neither shall death penalty be imposed unless for compelling reasons involving heinous crimes the Congress thereafter provides for it. There is almost nothing more deplorable than receiving news of a crime that discounts both the honor and the life of the victim. Filipinos are repeatedly angered by increasing reports of crimes of rape, with more rage in these cases that come with the death of the victim. Honor and chastity is as priceless as life. The danger does not only come from unknown persons, but at times from within the commerce of the home that should have been safe. Criminals have violated and victimized even children of mean ages. The features of the victims are lost, families are destroyed, and the shame of the country follows still growing number of the crimes of rape. The state has a duty to protect its people from those who have lost their moral values. The increasing incidence of rape, and especially those that result in the death of the victim, must be addressed. The present bill is being filed separately from similarly intended bills for other kinds of crimes in order for the bill to be given the greater consideration that it deserves, and with this thing. Attention to crimes of rape as against other crimes. This will show that the state is deliberate in strengthening its responsibility to secure the safety of people in the country against those who want to violate their honor.
Article 84. Place of execution and person who may witness the same. The execution shall take place in the penitentiary of believed in a space closed to the public view and shall be witnessed only by the press assisting the offender and by his lawyers and by his relatives not exceeding.
Article 85. Provision relative to the corpse of the person executed and its burial. So, Article 85, it talks about unless claimed by his family, the corpse of the culprit shall upon the completion of the legal proceeding subsequent to the execution be turned over the Institute of Learning or Scientific Research, first applying for it for the purpose of study and investigation provided, such as institute shall take charge of the decent burial of the remains. Otherwise, the director of prisons shall order the burial of the body of the culprit at government expense, granting permission to be present treat to the members of the family of the culprit and other friends of the latter. In number of case shall the burial of the body of a person sentenced to death be held with prompt.
Reclusion temporal, prison mayor, prison correctional, and arresto mayor. So, Badi Balduesa is tackled in the Article 40, and which is the reclusion perpetua, reclusion temporal, prison mayor, prison correctional, and arresto mayor. So, the penalty of reclusion perpetua, reclusion temporal, prison mayor, prison correctional, and arresto mayor shall be executed and served in the places the penal established the penal establishment provided administrative code enforced or which may be provided by the law in the future. So first is the reclusion perpetua. The reclusion perpetua is the penalty shall be from 20 years and 1 day to 40 years. Example, the crime of rape shall be punished by reclusion perpetua because reclusion perpetua is imposed from crimes punishable under the revised penal code, whereas life imprisonment refers to offenses punishable under special laws. And reclusion temporal is the penalty of reclusion temporal shall be shall be from 12 years and 1 day and 1 day to 20 years. Prison mayor and temporary disqualification. Example, if a child in conflict with the law is charged with murder, the prescribed penalty to be actually imposed is that the reclusion temporal be, temporal because of the privilege mitigating circumstances of minority, and the prison mayor and temporary disqualification prison correctional involving the punishment, treatment, and supervision of persons who have been convicted of crimes. And arresto mayor, the duration of the penalty of the arresto mayor shall be from 1 month and 1 day to 6 months.
So, Article 87, the destierro. Destierro is tackled, any person sentenced to destierro shall not be permitted to enter the place or places designated in the sentence, nor within the radius therein specified, which shall be not more than 250 and not less than 25 kilometers from the place designated. So, explanation. So, destierro is like an illegal, just like a married person who having surprised his spouse in the act of committing sexual intercourse with another person.
Arresto minor. The penalty of arresto minor shall be served in the municipal jail or in the house of the defendant himself under the surveillance of an officer of the law, when the court so provide in its decision, taking into the health of the offender and other reason which may satisfactory to it. Or it means that it serves where in the municipal jail or in the house of the offender, but under the surveillance of an officer of the law whenever the court so provides in the decision due to the health of the offender. But the reason is not satisfactory just because the offender is respectable member of the community. That's it.